If you are applying for a marriage green card, here is the uncomfortable truth. Even real marriages can get denied by USCIS. Not because USCIS thinks you are lying about loving your spouse, but because the case file does not prove what the law requires, or because something else in the background makes the applicant ineligible. And today, we are going to break this down in plain English. By the end of this video, you will know 3 things. First, what USCIS is actually deciding when they look at a marriage case. Second, the most common reasons genuine couples get denied, including the ones people do not realize are denial triggers. And third, a practical checklist you can use to reduce risk and respond correctly if you get an RFE or a notice of intent to deny. Here is the part most people miss. A marriage case is not one decision. It is usually multiple decisions layered together. In many cases, USCIS is deciding 2 main questions at the same time. Question 1. Is this a real, bona fide marriage? Meaning you intended to build a life together and not just get an immigration benefit. Question 2. Even if the marriage is real, is the immigrant spouse eligible for a green card under the rules? Meaning they are admissible, they qualify for the process they are using, and the paperwork is correct. So you can have a genuine relationship and still lose the case on technical proof issues, missed deadlines, financial sponsorship problems, or inadmissibility issues that have nothing to do with romance. Now, quick definitions in plain English. A marriage green card usually starts with Form I-130, which is the petition to recognize the relationship. If the spouse is inside the U.S. and eligible, they may file I-485 for adjustment of status. If the spouse is abroad, the case typically goes through consular processing, which is commonly called a CR1 or IR1 immigrant visa, depending on the length of the marriage, though the labels can vary by situation. And almost every marriage green card path relies on an Affidavit of Support, Form I-864, which is the financial sponsorship contract. It also often involves a medical exam, Form I-693, and an interview. So when people ask, why did my real marriage get denied? The answer is usually that one of these layers failed. Here are the 2 biggest denial buckets. Bucket 1 is relationship proof problems. Not enough evidence, inconsistent stories, red flags, or credibility issues in the interview. Bucket 2 is eligibility and compliance problems. Missing documents, wrong forms, late responses, sponsor income issues, medical exam issues, prior immigration history, or something that triggers inadmissibility. 2 groups tend to be at the highest risk. The first is couples who are real but underdocumented, meaning they did not combine their lives on paper, or they do not know how to present what they have. The second is couples with any prior immigration complications, like previous overstays, certain entries, prior removal orders, criminal issues, or a history of filings that creates questions. Myth versus reality moment. Myth. If our marriage is real, USCIS has to approve. Reality. USCIS must follow legal standards. A real marriage is necessary, but it is not sufficient. You must prove the marriage is bona fide, and the immigrant spouse must be eligible for the benefit. Another myth. If we bring a lot of photos, we are safe. Reality. Photos help, but photos without shared life evidence often do not carry the case. Photos show you were together. They do not always show that you built a life together. Now let us walk through the biggest reasons real marriages get denied and what to do about each one. Reason number 1. Not enough bona fide marriage evidence, or evidence that is too one-sided. USCIS is looking for proof that your marriage is more than a ceremony. They want to see that you actually merged your lives. The strongest evidence is usually the boring stuff: joint lease or mortgage, joint bank statements, joint insurance, shared bills, joint tax returns if applicable, kids' birth certificates if you have them, and consistent documentation over time. Denials can happen when couples submit mostly wedding pictures, chat screenshots, and a few affidavits from friends, but nothing that shows shared responsibilities. Another trap is submitting evidence that only shows the immigrant spouse at the U.S. citizen or permanent resident spouse's address, but not the other way around, or evidence that is all recent and looks rushed. Here is the part most people miss. USCIS also cares about continuity. A pile of evidence from 1 month can look manufactured. A smaller amount of evidence spread over many months can look more authentic. What to do? Build a timeline. Start it when you met, then dating, engagement, marriage, moving in, major trips, family visits, and shared milestones. Then match evidence to each phase. You are not trying to overwhelm the officer. You are trying to make it easy for them to say yes. Reason number 2, weak joint financial and household proof, especially when couples live apart or keep everything separate. Some real couples keep separate accounts. Some live apart for school, work, military service, caregiving, or immigration status. That can still be real, but it is harder to prove because the typical evidence is missing. USCIS may view separate finances and separate addresses as a red flag unless you explain it clearly and support it with documentation. If you live apart, you need to show why and show your ongoing commingling and intent to live together. That might include travel records to see each other, consistent communication, shared financial support, shared plans like a signed lease starting in the future, or letters from employers. But be careful. Do not create fake documents. Use real records and provide a clear explanation. If you live together but have no joint bills, consider which joint items are realistic for you. Renter's insurance, utility account, a shared phone plan, authorized user on a credit card, beneficiary designations, or a shared membership. This is not about gaming the system. It is about documenting the life you actually live. Myth versus reality. Myth: we do not need joint documents because our families know we are married. Reality: family support letters can help, but USCIS gives more weight to objective records that are harder to fake. Reason number 3, inconsistencies and errors on forms, dates, and prior history. This is one of the most common ways real couples get in trouble. You would be surprised how many cases have mismatched addresses, inconsistent employment dates, different versions of how you met, or missing prior marriages. USCIS compares everything: the I-130, I-485, I-864, the medical form, prior filings, visa applications, and what you say at the interview. Even small mistakes can damage credibility if they look like you are hiding something. A classic example is when one spouse lists a move-in date as March and the other lists it as June. Or one spouse says you met in 2020 and the other says 2019. These might be innocent memory differences, but if there are many, the officer may conclude you are not living the same story. Another key risk is prior immigration filings. If the immigrant spouse previously filed with another spouse or had prior petitions filed for them, USCIS may scrutinize the case more closely, even if the current marriage is real. What to do? Before filing and before the interview, do a consistency check. Create a shared timeline document with key dates: first meet, first trip together, engagement, wedding, move-in, major address changes, prior marriages and divorce final dates, and prior visa entries. Make sure the forms reflect the same story. If there is a complicated fact, address it directly instead of hoping no one notices. Reason number 4, interview problems, including communication gaps and red flag dynamics. Let us be clear, not every case is interviewed, and interview experiences vary. But interviews are where real couples can accidentally create doubt. The officer is assessing credibility. They are listening for consistency, natural knowledge of each other, and whether your answers match your documents. Common problems include spouses interrupting each other, getting defensive, over-explaining, guessing instead of saying, "I do not remember," or giving answers that contradict the file. Language barriers can also create issues. If one spouse is not comfortable in English, they may need an interpreter in certain situations, depending on the type of interview and rules. If you do not understand a question, it is better to ask for clarification than to answer incorrectly. Here is a big micro hook. This is where people get denied, even with a real marriage. If the officer believes there are material inconsistencies, USCIS may issue a request for evidence, schedule a second interview, or send a notice of intent to deny. It is not always immediate, but the interview sets the tone. Practical tip: practice answering common questions calmly. Not scripted, just familiar. Things like how you met, daily routines, who pays which bills, details about your home, and key family facts. And do not bring fake props. Bring organized, real evidence. Reason number 5, prior marriages not fully documented or not legally terminated. This one is huge and often overlooked. If either spouse had a prior marriage, USCIS will want proof that the prior marriage ended legally, typically with a divorce decree, annulment order, or death certificate. Denials can happen when couples submit incomplete documents, unclear translations, or documents that do not show finality. Another issue is when the divorce date overlaps with the new marriage date. Even if it is a simple clerical misunderstanding, it can create serious problems because USCIS must determine the current marriage is legally valid. What to do? Collect certified copies if possible. Ensure translations are complete if needed, and verify dates. If there is any complexity with foreign divorces or multiple jurisdictions, that is a moment where many people consider professional help because validity can be technical. Reason number 6, affidavit of support. I-864 problems, like income not meeting requirements or using the wrong household size. Remember, the I-864 is not a casual form. It is a contract. USCIS can deny or delay cases when the sponsor does not qualify financially and there is no acceptable joint sponsor, or when the sponsor submits the wrong evidence. Real couples often assume the relationship proof is the main thing, and they treat I-864 like a paperwork formality, but it can be a make or break item. Common issues include: sponsor does not meet the income threshold. Sponsor uses the wrong household size. Sponsor submits tax transcripts that do not match claimed income. Sponsor is self-employed and does not provide enough proof. Or, sponsor submits an I-864A incorrectly for a household member. What to do? Read the I-864 instructions carefully and use the evidence types USCIS typically expects, like tax transcripts and proof of current income. If income is close to the line, do not wait until the last minute. Explore whether assets or a qualified joint sponsor are options in your situation and document it cleanly. Myth versus reality. Myth: if my spouse is working now, we do not need the sponsor to qualify. Reality: the sponsor must qualify under the rules, and the intending immigrant's current income may or may not count depending on the circumstances and documentation. Reason number 7, missing RFEs, NOIDs, biometrics, or deadlines. This is the most painful category because it is often completely avoidable. USCIS will often give you a chance to fix a problem through a request for evidence. A NOID is more serious. It means USCIS intends to deny unless you respond convincingly. Denials happen when couples move and do not update their address properly. They do not check their online account. They miss a mailing, or they respond late. Another denial trigger is submitting an incomplete response. If you get an RFE and you only answer half the questions, USCIS can deny even if you had the missing documents. What to do? Treat every USCIS notice like a deadline you cannot miss. Track your case in your USCIS online account if available. Keep copies of everything you submit. Use a checklist. And if you get an RFE or NOID, read it 3 times, then build a response packet that answers each point in order. Reason number 8, medical exam. I-693 issues, including expired exams, missing vaccinations, or incorrect forms. This sounds minor, but it causes delays and sometimes denials if not corrected. Medical rules can change over time, and the timing of when the medical is valid can depend on when it was signed and when it is submitted. so do not assume last year's exam is still good. Errors can also happen when the civil surgeon does not complete the form correctly or seals it properly. What to do? Use a qualified civil surgeon. Check that the form edition is current at the time you sign, and keep a copy for your records. If USCIS requests a new medical, do it quickly and submit exactly what they ask for. Reason number 9. Inadmissibility issues and prior immigration history, like unlawful presence, misrepresentation, prior removal, or certain criminal issues. This is the category where a real marriage does not fix the underlying problem by itself. Many viewers are shocked by this because the marriage feels like it should override everything. But immigration law has separate eligibility rules. For example, if someone entered in a way that does not allow adjustment of status, or they have a prior order, or there is an allegation of misrepresentation in a past visa application, the case can be denied unless there is a legal pathway to address it, sometimes involving a waiver. I am not telling you that you need a waiver. I am telling you to not ignore your history. Here is a key point. USCIS already has a lot of your records, and they can request more. So it is better to be accurate than to hope something is forgotten. If your case involves any of these complexities, it is smart to slow down, gather your records, and consider getting qualified help, because the wrong filing strategy can create new problems. Reason number 10. Not attending required appointments or failing identity and security checks. Most people pass these steps, but denials can happen if biometrics are missed, if identity cannot be verified, or if there are unresolved issues in background checks. This is not something you can fix with extra photos. It is an administrative and eligibility issue. Now let us make this real with 2 example scenarios, based on patterns that show up again and again. Example scenario 1. A genuine couple, married 1 year, both working, busy life. They file quickly with lots of wedding photos, messages, and affidavits. They do not have joint accounts because they plan to combine finances later. They live with relatives, so no lease is in their name. At the interview, they disagree on the exact move-in month and who pays the phone bill. None of this means the marriage is fake, but the file does not show a shared household, and the interview created inconsistencies. They get an RFE or a NOID asking for stronger evidence and explanations. If they respond late or with more photos only, the case can be denied. The fix is a structured response. Add objective proof like mail showing both names at the same address over time, insurance, beneficiary paperwork, affidavits that include specific details, and a clear letter explaining the living arrangement with supporting documents from the relative plus proof of shared expenses. Example scenario 2. A real marriage where the relationship evidence is strong, but the sponsor income is weak and the immigrant spouse has a complicated entry history. They file without realizing the I-864 household size was counted wrong, and they ignore a prior overstay because they think marriage erases it. USCIS issues an RFE for the I-864 and later raises eligibility questions. The couple panics and submits partial documents. The case gets denied, not because the marriage is not real, but because the eligibility and sponsorship pieces were not handled correctly. The fix is to treat the case like 2 projects: relationship evidence and eligibility strategy, each with its own documentation and plan. Now, what should you do right now if you are preparing a marriage green card, or if you already filed and you are worried? Here is a practical do this and avoid this checklist. Do this. Build a shared timeline with key dates and addresses, and keep it consistent across all forms and interviews. Do this. Submit a balanced evidence packet that includes both relationship proof and shared life proof, spread across time. Do this. Prioritize objective documents, leases, bank statements, insurance, taxes if applicable, shared bills, beneficiary designations, and mail showing cohabitation. Do this. Keep a clean copy of everything you submit, organized by category, so you can respond fast to an RFE. Do this. Monitor your case status and your mail, and update your address promptly if you move. Do this. Prepare for the interview by reviewing your own file, not by memorizing lines, but by refreshing key facts so you do not guess under pressure. Do this. If there are sensitive issues in the background, request your records where appropriate and consider qualified guidance before filing. Avoid this. Do not submit fake documents, altered statements, or staged evidence. That can turn a fixable case into a permanent problem. Avoid this. Do not flood USCIS with thousands of pages of low-value screenshots. Quality and organization matter. Avoid this. Do not ignore an RFE or NOID or assume it is optional. It is not. Avoid this. Do not contradict your own forms at the interview because you did not review what was filed. Avoid this. Do not make irreversible moves, like international travel or quitting a job, based only on assumptions about timing or approval. Verify your specific situation and the rules that apply to your filing path. Here is another myth versus reality that saves people. Myth: if USCIS suspects anything, they will just deny immediately. Reality: USCIS often issues an RFE or NOID first, giving you a chance to clarify. But you have to respond correctly, with evidence that directly answers the concerns. Now, what should you watch next? 1. Watch for updates in your case account and mail, interview notices, RFEs, or requests for updated medicals. 2. Watch for timing pressures. If your work authorization or travel document depends on a pending application, plan for delays and do not assume dates. 3. Watch your evidence trail. Keep building it while the case is pending. Continue adding joint documents, new addresses, new insurance renewals, and shared life proof. Because if you end up in a second interview or need to respond to a concern, the best evidence is often what happened after filing. Here is the calm bottom line. Most real couples do get approved, but USCIS denials happen when genuine couples treat this like a romance test instead of a documentation and eligibility process. So let us recap in 5 quick points. 1. USCIS is deciding both whether the marriage is bona fide and whether the immigrant spouse is eligible. 2. The most common denials come from weak shared life evidence and inconsistent information. 3. The I-864 financial sponsorship and deadlines like RFEs and NOIDs can sink a real case. 4. Medical and background eligibility issues are separate from relationship proof and must be handled carefully. 5. You can lower your risk by building a timeline, organizing objective evidence, and responding fast and completely to any USCIS request. If you found this useful, consider subscribing and turning on notifications because we cover USCIS processing trends, interview preparation, and practical ways to avoid delays and denials without panic. And if you have a question, share your general situation in the comments, like spouse is inside or outside the US, and whether you are doing adjustment of status or consular processing, and I will cover the most common next steps in a future video.